I would now like to introduce our presenter, Cynthia Lazar. Cynthia has been practicing in all areas of labor and employment law since her call to the bar in 1995. Her practice also includes human rights, privacy, defamation, and accessibility. Cynthia has the designation of AWICH, Association of Workplace Investigators certification holder, and brings extensive experience in conducting workplace investigations. Cynthia has built strong, long-lasting relationships with her clients and enjoys working with them to navigate their day-to-day employee-related concerns, union relations, and collective bargaining. Cynthia taught the Labor and Employment Relations course at the Asper School of Business for 9 semesters and enjoyed working with human resource professionals in the making. She's also a very accomplished speaker in the areas of collective bargaining, basic employment law, workplace investigations, human rights, and accessibility. She is a regular contributor to the Globe and Mail's 9 to 5 column. Since 2008, Cynthia has been a member of the Winnipeg Board of Jewish Education and is a past president of the National Council of Jewish Women of Canada, Winnipeg section. She is the honorary solicitor of the Rady Jewish Community Centre. We are so pleased to have her here today, and without any further ado, I will pass it over to Cynthia.
Okay, so I'm going to try to share my screen. That did when Nina and I were practicing, so hopefully this will work. And okay, there we go. So first of all, what is civil litigation? Civil litigation means you're going to court on something that's a non-criminal matter, and it includes a breach of contract, so it could be commercial contract, employment contract, etc. Could be estate matters, breach of fiduciary duty, torts, not the deserts, that would be much better than this, but torts are non-contractual civil wrongs. So that is something has gone wrong, some bad thing has happened to you, or you've done some bad thing to someone else, but it's not based in a contract. It's not a breach of contract. It's, some examples are negligence. So maybe you left the tap running in your bathtub and it overflowed and ran down into the apartment below you. That could be an issue. There's no contract between you, but you've caused some damage. Defamation, that would be maybe somebody has said something about you that is untrue and would lower your reputation in the community. So if someone's called you a thief or a liar or something like that in public. Trespass or nuisance, well, I guess the water is a better example of nuisance negligence, but the point is that these are things that are not contained in contracts, but there's something that has gone wrong and you've suffered some damage. So that's what torts are. Not as good as the cake. The family law is also covered by civil litigation, but they have their own set of rules. So very similar to this. There's a lot of overlap, but it's not exactly the same. And I'm not covering that. I don't practice in family law. So in terms of remedies, so remedies are, by its nature, that means things that you can do to fix what has gone wrong, to remedy what has gone wrong. Can take 2 forms. It can be damages, which is money, and then it can be non-money issues, which are usually equitable remedies. So it's a bit of a distinction. If you're not a lawyer or a law student, more likely you don't really need to know that. But how are, so by accident. Okay, so damages are about money. So how are you going to calculate that? How much money are you owed for this wrong thing that's happened to you? If the wrong thing that's happened to you arises from a contract, from a breach of contract, then the court is supposed to put you back in the position that you would have been in had the breach not occurred. So if the contract had been followed, you would have received $100. Because they breached the contract, you only received $50. So your loss is $50. So that's the difference. They're putting you in the position you would have been in had the breach not occurred, had the contract been followed. In the non-contractual things that can go wrong, so torts. The court is trying to restore the plaintiff, restore the person who's been harmed to the position they would have been in had the tort not occurred. So if there's the escape of water from your apartment to the one below, for example, would be a nuisance because you allowed something to escape your property onto someone else's, and it caused damage to their bathroom, and it cost $10,000 to fix their bathroom. That would be the cost of, that would be the damage award in that case. It would be the amount that would cost to put the plaintiff back in the position they had been in had the tort not occurred. So there's a few different types of damages. Again, damages that we're talking about money remedies. So this is where you're getting cash for something. So special damages are something that is quantifiable. You can figure out how much is owed. So someone was supposed to pay you a certain amount, and that's in the contract. They haven't paid you that amount. You can figure out how much that amount is. It's easy to put a dollar figure on that. General damages is more difficult. That is where there's not an exact amount set out in the contract. It's just something is owed to you, and the judge is going to have to figure out how much you should get for this. You will very often in a statement of claim see a claim for, right at the beginning, you put in a list of all the things that you want to get from this lawsuit, and you very often have both special damages and general damages listed. So special damages, again, are the ones that you can very easily put a number to, that you can calculate, and general damages is a little more fuzzy, and that's something that the judge will calculate. Damages as prescribed by a contract are also called liquidated damages. That's really a type of special damage because it's something you can calculate, but we call it liquidated damages, where it says, for example, in a contract that if you violate this contract, you will pay X amount. So it's already in there. It's already in the contract how much that's going to be. Aggravated damages and punitive damages are a little bit different. An aggravated damage is awarded for compensation. It's to compensate you for a non-monetary loss. So, for example, I'll use examples from employment law because that's my area of practice, so I'm most familiar with that. If you are fired from your job and it's a wrongful dismissal, you would first look to see in your contract, is there a prescribed amount that you are supposed to get if your employment is terminated without cause? And it might say, get 6 months pay. That would be special damages because it's quantifiable, or you can call it liquidated damages because it says actually in the contract this is going to be. If the employer fires you in a really terrible way, in a really way that's calculated to cause humiliation or embarrassment. So in front of the, at the office Christmas party, everybody's having a good time and they grab the mic and they say, hey, by the way, I hope you're all enjoying this party and have a great Christmas, and John is fired because he's terrible. So say goodbye to him, you'll never see him. That would be a really terrible way to fire someone. And there's some losses that John in that case would incur that are beyond just the pay, the humiliation and the upset in the way that he was terminated, in the way he was dismissed, give him some other damage that needs to be compensated, and that would be through aggravated damages. So his loss in that case isn't monetary. He's not lost out on any money, but he has had a loss in terms of humiliation, anxiety, mental health effects, and so on. So the aggravated damages would compensate him for that loss. Punitive damages are not there to compensate for any loss at all. They're there to punish, to make sure that this person's not going to do that again. So in the example I just gave you, the judge may say, okay, I'm going to award you, John, 6 months of pay for your pay in lieu notice. That's because of your dismissal. I'm also going to award you $10,000 for your aggravated damages because of the horrible insensitive way that you were fired. But also, I'm going to award an additional $10,000, not to compensate John for any loss that he had, but to punish his employer to make sure they learned their lesson and never do this again. And that would be punitive damages. Those are very rarely awarded, but that's what those are. The last one I have listed here is nominal damages, and that nominal just means sort of in name only. So very small amount of damages just to kind of make a point because you have to. So this is sometimes awarded, for example, in defamation. So maybe someone said something bad about you, but then they took it back right away, or they only told one other person, or maybe it wasn't really that bad, or maybe they told someone something and they didn't believe it. It didn't change their view of you. It didn't change your reputation in that person's eyes. So maybe there was a defamation, but the effect of it was very small. And so the judge might award a very small amount. There are cases where $1 or $10 or $500, so small amounts legally speaking. $500 is a lot to a lot of people, but in not legally speaking, it's a nominal damage. It's quite low. So those are the remedies. Those are the damages. That's the money. Now we'll talk about equitable remedies, which are not money remedies. There's a lot of them, and I'm only giving you examples because there are many, many more that are just, we'd be here all day. So these are some examples of the more common ones. So specific performance is in order to complete a contract. So if you have reached a contract and one side says, I'm not carrying this out, you can go to court and get an order forcing them to carry it out, to complete the contract. This can't be done, like I said, my area of law is labor and employment law. So you can't actually do this in terms of what we call a personal service contract. So an employment contract or something where somebody is personally going to carry out a service, because a court ordering a person to actually, you must go back and work for this person, you must go and do this work, is kind of akin to slavery. And so that for public policy reasons, we don't use specific performance for personal services contracts. That would be compensated in money, in damages, not specific performance. The court's not going to order somebody that they must go and work somewhere for some period of time. Rescission, if someone has breached a contract and you're not the one who's breached it, someone has breached your contract with them, the other party has, you can bring a case in court asking the judge to cancel your contract and put you back in the position you were in before you entered it. So maybe you entered a contract for certain work to be done and you've started the work, you've put something out there, or maybe you've purchased materials or you've done something, and the other side says, I'm backing out. You can ask the court to put you back in the position you would have been in before you entered the contract, so to make you whole. Rectification is correcting a written document to reflect your true intentions. So maybe you have entered into a contract with someone and you both agreed on what it would be, but you wrote it down wrong, or you forgot to write something into the contract. You can ask for rectification to ensure that the contract actually reflects what your agreement was. And accounting, that's usually to remedy breach of fiduciary duty, so or an unjust enrichment. So that would be a case where, for example, someone owes you, has taken over some part of your business that they shouldn't have. You can ask for an accounting. So a judge will go through all the financial records to determine how much money this person has made from this thing that should have been, this piece of business that should have been yours. And you can go through that accounting and so they will figure out how much should have been yours and then order that person to pay you that. Constructive trust is sort of a step sort of before an accounting. Say there's been an unjust enrichment. Someone has, you've given somebody money to buy a certain stock for you and or a business for you, and it's supposed to be in your name, but you've just asked them to take care of this for you. They take your money, they buy the thing, and then they try to keep it themselves. That would be an example of where a constructive trust would be found. So a court would say, yes, this thing may be in your name, but you're holding it for the other person's benefit because you bought it with their money for their benefit. It was supposed to be transferred to them. You never did that. That was, you backed out of the deal. There was some dirty dealing here. And so you may have bought this stock or property or business or whatever it is, but you are holding it in trust for the other person. The other person gets the benefit of it. Then we get to injunctions. So an injunction is a court order. I can slow down. I talk too fast and then I see that, oh, we've got actually lots of time left. So an injunction is a court order that you can get that says that someone has to either do something or not do something. So you can get an injunction ordering someone to return your property, to just, provide certain information, for example. You can also get an order telling someone that they have to not do something. So they can't, an injunction ordering picketers not to block a driveway where people are driving in front of a business that they want to picket against. That would be an injunction ordering someone to not do something. And I'll give you an example from a case that I was just dealing with last week. An employer hired an IT company, well, it was one person, an IT contractor, to take care of their computer systems and their social media and their website and all of that. And they decided to end the contract, and this person was not very happy and was refusing to provide the passwords to all of the company's different sites. They were also set up a separate website that looked like the employer's website. So it looked like the company's website, but the company's website was, abccompany.ca. And this guy set up one that said abccompany.com and was using this to divert traffic away from the company's own website. So fortunately, it all worked out with just a mean letter or two, but we could have, if we wanted to, brought an application for an injunction ordering him to do something, which is to hand over the passwords, and also an injunction ordering him to not do something, which is to not pursue these fake websites, the .com website. So you can look at that two ways: as an order to do something or an order to not do something. And there's a few different types of injunctions depending on the time frame that you are looking to cover. So an interim injunction is a court order to do something or to not do something that continues in force until a specified date or a further order happens. So I'm ordering this, here's an interim injunction. You are not to contact this person. Don't phone them, don't email them, don't contact this person until this date or until this order is finalized or whatever it might be. That's an interim injunction. An interlocutory injunction continues until the final hearing or determination that is to be made. I'm sorry, my notes here are missing a few things. So it continues until a final warning, should only have one eye, or a determination can be made. There should be a space there. It can be without notice, but only for 10 days, and it can be extended. So you may find yourself in a litigation where you've got a court date set, but it's 2024, and your court date isn't until 2025. You can ask for an order that says that they're not allowed to destroy these documents until the final court date is heard in 2025. That would be an interlocutory injunction because it goes until the final matter is heard. If you get that order without notice, that's what I'm sorry, that bullet needs work. But if you get that final, if you get that order without notice, so you have just gone straight to court and you've gotten this order without telling the other side you're going to do it, that lasts for 10 days and then it can be extended. And that's to give the other side an opportunity to come and to court and explain why the order, the injunction should not be in place. So we have this kind of thing is usually done when you are worried that something is going to be destroyed or done before the hearing can take place. So maybe you're worried that computer files will be deleted or documents will be changed or lost or hidden or destroyed. You might get an order saying that these things have to be preserved, or maybe there's a special kind of order where you can actually get documents taken out of the other side's premises to preserve them until the hearing is heard. And this can be all kinds of things. So there may be an order in terms of if, okay, and I said I don't practice family law, but that's the example that's coming to me. So it might be you can't move your children from one school to another until final custody matter is heard. That might be an example. So you can't, it's in order basically not to make a change or to do something or not do something until the final determination at trial or hearing or what have you. A permanent injunction is just what it sounds like. This is there forever. It's there until, or until it's lifted by another court. So it's a permanent injunction, it's just there. And that means that you can never do this thing, or you must do this thing and keep doing it. So that order to do something or to not do something is permanent. In terms of injunctions, a court is going to look at a few things in deciding whether they should issue that order. They're going to look at the merit of the case. Is this a good case? Do you have a reasonable case to put forward? They're not making a final determination, but if it looks ridiculous and without merit right on its face, they will take that into account. If it looks like it could be a pretty reasonable case, then that will be taken into account. Will there be irreparable harm? So if I order you to do this thing or to not do this thing, is there going to be harm done to one of the parties that can't be compensated in money? So if I make you do this thing, if I issue this order telling you to do something, is there going to be something that happens to you that we can't fix? So if I order you to do this thing with your business, is it going to basically cause the closure of your business and you'll never be able to get it back up? Or is it something you'll, if I'm issuing this order for you to preserve certain documents, because if I don't, you'll destroy them and then you can't ever get them back. So that would be irreparable harm. If it's something like, oh, you might lose this one customer, but your business will continue, we can figure out how to pay you for that in costs. You might lose this one contract, but we know how much that contract is worth, so we can pay you for that. We can figure out in dollars how much that is, so maybe there's not irreparable harm in that case. We also look at the balance of convenience, or sometimes they call it the balance of inconvenience, which is harder for, which side will have the greater impact on them if the award is granted or not granted. So it's all of this balancing that takes place for the judges when they're deciding whether or not to order an injunction. The next one is costs. So this is not about the costs of, this is different than the damages that we talked about, you breached this contract, I lost $100, so you owe me $100. That's different. That's the damages you get for the breach of contract, or for the negligent damages from negligence or defamation or whatever else we talked about. Costs is about court costs. How much have you had to pay to fight your case? How much have you paid a lawyer? How much have you had to pay the court in filing fees? Maybe you've had photocopying fees, or you've had to pay a court reporter for a transcript. All of those things cost a lot of money. You might have had to pay a witness to come in from some other place, or to attend, or to get an expert report, for example. All of those things are costs. And our system is a loser pays costs. So if you go to court, you sue someone and you lose, you will have to pay their costs. If you sue someone and you win, they will have to pay your costs. That all sounds very nice, but it's not exactly how it works, practically speaking, in real life. In Manitoba, the amount that you pay for costs is determined on a tariff that is contained in the Court of Queen's Bench rules, not the Act, the rules. And the tariff looks kind of like a menu. And it says, for drafting a statement of claim, you get X number of dollars. And it doesn't matter how much you actually paid for that, you get what's on the menu, you get what's on the tariff. If you go to a trial, you get a certain amount of dollars for each half day of the trial. It doesn't matter if your lawyer charges you $200 an hour, $500 an hour. If you are self-represented and you do it yourself, actually, you don't get costs if you are self-represented. But with your lawyer, it doesn't matter what your lawyer charges you, whether it's a lot or a little, you get the amount that is set out in the tariff. It usually in Manitoba, in my experience, works out to about a third of your actual costs. It's probably actually even less than that now because people's rates have gone up, and I don't think the tariff has kept track with that. So it is quite a bit less than what you actually end up paying out of pocket. It's different in different jurisdictions. In Ontario, it's much closer to the full amount that you actually pay. But in Manitoba, it's quite limited, and it's done that way on purpose to increase access to justice. Because the thought is that if you had to pay the other side the full amount, then you might not bring forward what you feel is a reasonable case. And it may be that you've got a reasonable reason to believe that you have a case, and you still lose. They don't want to stop you from bringing forward reasonable cases. Now, unreasonable cases, you might actually get ordered to pay more than the tariff. And that is in the next section of this types of costs. We have party-party costs. That's between party and the party, the plaintiff and the defendant. It's just called that for some reason. And that is cost based on the tariff, which, as I said, is about a third of your actual costs. Solicitor client costs are awarded in exceptional circumstances. So that would be that example where you bring a case where you know there's no chance for success, where you behave in a really unreasonable manner and it causes everybody to have to incur more costs. Those kind of situations are pretty exceptional, and that is closer to the actual cost. So if the other party is being really unreasonable, has brought a ridiculous case, or has put up a ridiculous defense, is doing all kinds of things to make things longer, dragged out, more expensive, you can ask for solicitor costs. But it's really only awarded in really egregious cases. For preliminary matters, so if you bring, you may have file a statement of claim, and that's going to go through many steps until you finally get to a trial. That's one thing. But you may have all these steps along the way. So you may have to bring motions along the way, a motion for summary judgment, or a motion for to compel particulars, or a motion to have something struck out. So there are little preliminary steps that you get along the way before you get to a trial. Costs for those preliminary steps can be assessed in one of two ways. They can be costs. The judge can say the costs are in the cause. And when the judge says that, what they mean is that you wait to see who wins the main case, the trial at the end of the day, and whoever wins gets the cost for this preliminary step. If the judge says that you get costs in any event of the cause, that means that it doesn't matter who wins at the end of the day, you get your costs regardless. It doesn't matter what the outcome of the main case is. So if along the way, one of these preliminary steps is a ridiculous motion, a motion to strike something out, or a motion for something that is without merit, and the person should never have brought this motion, and it's wasting everyone's time and money, the judge will likely, in that case, award costs to be in any event of the cause. So whether you win or not at the end of the day doesn't matter. You have to pay the costs for this ridiculous motion that you should never have brought. So those are the different ways costs can be awarded. Interest is awarded. There's two kinds of interest. There's pre-judgment interest and post-judgment interest. So the pre-judgment interest runs from usually from when the statement of claim is filed until the judgment is issued. And then post-judgment interest runs from the date that the issue was filed until the day the judgment is finally paid. The rates are set by the court in each quarter. We don't use bank rates. It's the court sets its rates. The method of calculation is in the Court of Queen's Bench Act, not the rules, the Act. And it's really actually quite complicated because it's compounded quarterly. And so it's a complicated calculation to do, but it's set out in the Act. If you go onto the court's website, you will see that there is a tab there that you can hit to find out what the current pre and post judgment interest rates are. I did this yesterday, and so currently the pre and post judgment rate is 5%. That's actually pretty high. In 2022, it was 0.5%. So it is adjusted depending on what's happening in the outside world. But this is something that's set under the Court of Queen's Bench Act. And as I said, it's available on the court's website. We then get something called offers to settle. So an offer to settle is a formal document that you would serve to the other side saying, I'm offering to settle this case for this amount of money. And or on these terms, and it's set out in a court document. If a party fails to accept an offer that they should have accepted, cost consequences can be triggered by that. So what I mean by an offer that they should have accepted is, say I am being sued by someone and I offer to settle for $5,000. And they say, no, they don't accept that offer. And then they go to court and they win, but they only win $2,000. They should have accepted my $5,000 offer. We would have saved everybody a lot of time and effort, would have saved the court's time. So they should have accepted that offer. There will be cost consequences. Or say I offer to settle this case for $5,000 and the other side says no, and then they lose. They should have accepted my offer. There can be cost consequences. So there's a few things that have to be included in your offer in order to trigger the cost consequence. First of all, it has to be made at least 3 days before a motion or 7 days before a hearing or trial. A motion would be, those are those preliminary steps I talked about that happen before a trial, or 7 days before the hearing or trial. And it has to remain open for acceptance until the start of the hearing. If that's done, then we get to how the cost consequences work. If the plaintiff makes an offer that is not accepted, and then the plaintiff wins, and they win more, if the plaintiff makes an offer and it's not accepted and the plaintiff wins, then instead they get the party costs, that's the tariff costs, up until, for every step that's taken, up until the date of the offer. After the date that they made that offer, they then get double the tariff. So if you're supposed to get $250 for this particular step, now you get $500 for that particular step. So you want to make that offer as early in the litigation as possible so that if the cost consequences apply, you get more steps covered, more steps attracting that double the rate. If the defendant makes an offer that is not accepted, and the plaintiff wins, but they still should have accepted the offer. So they might win, but they win and they get the same or less than the offer. So they should have accepted that offer. The defendant, because the defendant lost and we have a loser pays system, the defendant pays the party costs. That's the cost on the tariff from the beginning of the litigation until the date the offer is made. And then it flips. After the date after the defendant made that offer that the plaintiff should have accepted but didn't, that from that point in the litigation on, for all those following steps, the plaintiff has to pay the defendant's costs on a party basis because they should have accepted the offer and stopped the whole litigation right there. So that, again, you want to make those offers as early in the process as possible so that even if you're the defendant and you make an offer and the plaintiff wins, but the win isn't as good or is just as good or the same as your offer, then you flip. And even though they win, they start paying your costs. So that's a really valuable tool. In terms of enforcement, after a court hearing or a court decision, you have to write up the court order. You submit it to the judge and you ask the judge to sign the order, and the judge will make changes if need be or sign the order as is. And you also submit what's called a bill of costs, which, as you recall, I said that the tariff where you determine the costs is kind of like a menu that you order off of. And it says, for a statement of claim, this amount, for motion, this amount, for examinations for discovery, this amount, for a trial, this amount. So the bill of costs is like the final bill of everything off that menu. So it looks like a list of everything you've ordered off that menu, the statement of claim, statement of defense, the motion, maybe, there's an entry for drafting an offer to settle, for all of these steps that could take place, and it adds up at the end. And it's for the both legal fees that are paid and also for disbursements that you've paid out. And you file that with the court and get that signed off by the judge as well. So once you have that bill of costs, that becomes like an order that says that the other side owes this amount. We now know exactly the right amount because it's in the bill of costs. You can do a couple of things to recover that money. You can seek a garnishment order, and that diverts money from somebody's paycheck or another payment that's due to them, and it's paid to you instead. So for example, if somebody owes you something, $10,000, you can get a garnishing order that you submit to their employer, and their employer will take something. There's a formula. They can't take the person's entire paycheck, but they take a portion of the paycheck, and instead of paying it to that person, they will pay it to you. Or if you know that they're going to get a payment from somebody else, you can issue them the garnishing order, and instead of paying the other party, they will pay it to you, and that will reduce the award that is owed to you and you can keep doing that until the award is totally satisfied. Another option is you can do what's called an examination in aid of execution, where you get to go and in front of a court reporter making a transcript, you get the other side in a room and you ask them all kinds of questions about what they have and what they don't have. So do you have a house? How much is the house? What is the address of the house? How is it held? Do you owe a mortgage on it? How much is the mortgage? How much is this worth? How many, do you have RRSPs? How much are your RRSPs worth? How many bank accounts do you have? What is in your bank accounts? Do you have a boat? Do you have a motorcycle? Do you have other valuable assets? Anything that you can think of, and they publish lists of them to, like, as a checklist to ask. So, whole lists of financial investments, bank accounts, assets, all kinds of pieces of art, anything. And you can get assistance with the sheriffs. Well, first of all, it will identify to you where this person's assets are, so you know how to go and collect them. And you can also get assistance from sheriffs to go and seize their properties for sale, so that you can pay off the amount that they owe you. Now, you can't get more. So if more than is owed to you, so if you are owed $10,000 and something is taken and it's worth 12, you can't take all 12. You only take the 10, and the other 2 belongs to the other party. And that's it. So maybe we can go to, I'm going to try to stop sharing this screen.